if you have ever brought a case in front of the appellate court.
I've done several appeals. Fortunately or unfortunately, it would have been an honor to do so. I never had to go to Sacramento and argue those. The appeals were decided by the written work. What an appeal is after an evidentiary hearing or a trial, one of the parties says, hey, something was done wrong here. There was a matter of law that was not applied correctly. The trier of fact, usually a judge, either did not have substantial evidence to make the decision, or they acted in an arbitrary or capricious manner. So the first thing that's done is set up the stage. There's very formulaic requirements of the pleadings that are done. They have to be done on certain colors, with a certain format, with certain spacing. And so it's a very regulated process. So every appellate judge up in Sacramento, we're in the 3rd District, would see basically the same kind of format and the same kind of binding for the appellant and the respondent. And in that case, you lay them out, you lay out the factors, you lay out what the issue of the case is, you lay out what the main issues are, and then you get into an in-depth, complex analysis of the law and why the law applies to the facts, and why, if you're in favor of the decision, you won in the trial court, that the judge ruled correctly. If you were lost, you're trying to persuade the appellate court that the judge made a mistake. And so you use your arguments. It's a fun and fascinating process, and thank you.
Thank you, Mark. Randy?
Typically, the appellate process involves a panel of judges, not just one judge. So, as Mark had described, and I think pretty well, the process of the appeal is if there is some kind of a legal mistake that has been so egregious under the law that it merits this panel of judges looking and saying, okay, is that mistake so egregious that we need to send, that it has prejudiced the case and we need to send the case back and do it again? I have, and I don't know if it's fortunate or unfortunate, some of the cases I've been involved on appeals are because I lost. So I guess those were unfortunate. Some are because I won and I had to defend, but in my years of experience I have argued before various courts of appeal 6 different times. One case twice out of independence, and it is a fascinating area of the law. Typically what happens is a lawyer that's involved in a case where appeal is going to be taken, if the lawyer, I think, is wise, will typically get assistance, if not to really take over and completely handle the appeal, but at least get somebody else to come in and help you. Because one of the dangers of a lawyer handling his or her own appeal is that typically the issue on appeal, unfortunately, often involves a mistake that the lawyer, him or herself, made. So what you see is that often in appeals, you get a lawyer that's going to get somebody else in to try and represent the client, so that the lawyer that made the mistake that resulted in the error isn't arguing his own case, his own mistake on appeal, which creates a significant possibility of conflict of interest with the client.
Thank you.
If I may add one follow-up.
Sir.
I think we'd all agree, one of the most important things the trial court judge can do is make sure the record is very clean and very clear, and that objections are very clear, and that evidence is properly marked and admitted, and that when someone makes a statement, the court reporter is able to hear it. That's one of the primary functions of a trial judge, is to make sure there is a good record, so that if it goes to appeal, the appellate court will have a real good sense of what happened in the trial court.
And typically those errors are in admissibility or unadmissibility of evidence. So I agree with Mark. You need a judge that knows the rules of evidence, a lot of experience in dealing with that, so you don't end up doing it all over again.